After 30 years of public service, I thought I had seen it all, and well, I hadn't seen it all, and like those who had gone before us, we probably thought the same thing, and we really hadn't seen it all. It really was an incredible 3 years. After a scotch or two, we were sitting there getting to know each other, and I just asked him, I said, Henry, what was it really like at Nuremberg? And we chatted about that, and I talked a little bit about Freetown. And then I said, how did you get through it? You know, we tend to, as we look at this in a very academic and in some ways dispassionate way, even though the gentleman before us, certainly there was a great deal of emotion. But there is a lot of humanness behind this, not so much as well as the victims, but also the wonderful teams that go out and try to carry the flag of Nuremberg forward into some rather dark corners of the world indeed. And so I asked him, I said, how did you get through it? And God bless him, and please, I hope I don't embarrass you, he said, Scotch. Civil Defense Force, and the presiding judge looked at me and said, Mr. Prosecutor, your opening statement. And when you stand up and you walk across, and you have a room full of Sierra Leoneans, West Africans, and etc., just leaning forward, and you walk up to that podium. Justice Robert Jackson was standing next to me, and ladies and gentlemen, I can assure you. And then we'll talk about some of the lessons learned in the world's first hybrid international war crimes tribunal. And then we'll talk briefly about some of the challenges that we have, the thematic challenges is what I call, we really are at a crossroads. We've already kind of alluded to some of that in those wonderful panels yesterday. Let's talk about the legacy. You know, it really is fascinating if you think about it. When Justice Robert Jackson and his wonderful team from all over the world arrived in Nuremberg, it was destroyed. Probably very little running water, electricity. When yours truly and my wonderful team arrived in Freetown in August of 2002, we had no electricity, no running water. The capital was 90% destroyed. It was a treaty-based created court. It was of the UN and not in the UN. And it had a similar mandate, and that is to prosecute those who bear the greatest responsibility. So we were going after relatively the 23 that destroyed West Africa, and particularly two countries, Liberia and Sierra Leone. And we were at the scene of the crime. We lived and breathed it and tasted and touched it every day while we were there. And I have to tell you, and I know these gentlemen have the same thing because I know they understand, is that that taste, that smell is still with them, and it's still with me, and it will be with me the rest of my life, of course. So again, we have to understand that when you go to do something like this, you leave a great deal of yourself there. And then, of course, we had a political time frame. I mean, the question was posed to me by the UN Security Council, and that was, can we deliver international criminal justice effectively and efficiently in a politically acceptable time frame? And we were really gunning for 3 years. Unfortunately, we're still there, but there's reasons for that, and we'll talk about that in a few minutes. But again, we were there with a political time frame. We wanted to get in, and even though there's a huge impunity gap that develops, I would posit to you, and I would love to chat with you about this during question and answers, we're going to throw the baby out with the bathwater, so to speak, if we don't use this mandate of greatest responsibility. It just can't prosecute everybody. It's impossible. Our wonderful colleagues in Nuremberg and Germany did the best they could over a period of years, but those were different political circumstances. You know, the difference between greatest responsibility and most responsible in Sierra Leone was greatest responsibility around 20. Most responsible, 100 to 300. Time in country, 25 years. If you just said responsible, it goes to 30, 35,000, and that's a generation worth of criminal justice. And what we'll do is that the world will not want to do it. And of course, the people certainly can't deal and move forward, and we have to get that out. My thesis is that any tribunal that remains in a region operating for over 5 years begins to unravel politically around the edges, and we can talk about that now and in the future. Also, they are, and they have been, proven to be efficient and effective. They're not perfect. I noticed I didn't say perfect, but there is an efficiency and effectiveness that is inherent in this type of arrangement. You've got a mission, you've got a certain amount of money, and you have a general time frame. But that's not rocket science. We do that all the time in business and government. So you go out and make your plan, you work your plan, and you get done with it. So I think that's important. But if you'll notice, not in the UN system. Now, those of you that have been in the UN system, when I went to Freetown, if I wanted to hire somebody, because remember we were of the UN but not in the UN, if I wanted to hire someone, I would hire them. And they would be sitting at their desk within about 4 weeks. That's a great way to start your prosecutorial plan and move out. Now, Carlo Del Ponte or Hassan Jallo would look at this with great jealousy because 13 months later, 14 months later, maybe, again I'm being a little bit facetious, but there's a long time frame related to the UN administrative and staffing rules. And I couldn't have done it. 3 to 5 years, get in, get out, greatest responsibility, but if I was burdened with the challenge of the UN personnel system, I'd still be hiring in some ways, because again, in the give and take of living in extreme situations, people come and go, and so it's incredibly, incredibly disruptive. I've talked about the flexibility. I think they're perfect complements to the ICC. You know, in many places of the world where there are these atrocities, they don't have a court system, so the principle of complementarity in domestic court arrangements really is weakened. And so I think that a hybrid regional international war crimes tribunal is the complementarity to the ICC paradigm. And of course, in my mind, and we can talk about this, you know, we were lucky. We had a truth commission there at the same time as we had a working tribunal. In my mind, that was luck, but also the right thing. Truth plus justice equals sustainable peace, and I really, really believe that. And this one, I think the chances of a long-term peace are really, really weakened. Now, like I said, I'm not going to go through all of this. I just want to let you know and highlight to you that there was a terrible tragedy for 10 years in West Africa, which really resulted in a murder rate, maiming, and mutilation of over 1.2 million human beings, most of which went unnoticed in the international community. It took a letter from President Tejan Kaba, almost in desperation, with a little bit plotting by the United States, asking for help. And he turned to the Security Council, which gave them the authorization to begin, and they had absolutely no respect. And so we wanted to make sure that they understood that the law was fair. So our registrar, Robin Vincent from the United Kingdom, did something that I really supported, and that is created a co-equal Office of the Principal Defender, where they got the same support as any other office in chambers in the special court, and that continues to this day. And I think that that is something that we all need to be thinking about, because again, when we're done, we're going to go home, but they're going to have to live with the result. And if the result is fair, even though it may not be the result they wanted, they'll be able to live with the result. And so I think that if they understand that they are innocent until proven guilty, and that they are defended vigorously, then I think they'll be able to understand the fairness concept that I'm putting forward. Now let's talk about, briefly, the lessons learned, because I think we have learned some lessons in the 4 years, 3.5 years that the Special Court for Sierra Leone has been in existence. I already talked about the narrowness of a mandate. In my mind, it has to be greatest responsibility. I'm not happy about that, but I also understand that if we want to have any accountability around the world at the international level in this war-weary, cynical world, we're going to have to go with greatest responsibility. It was the great political compromise that created the Special Court. Without greatest responsibility, there would not have been a Special Court for Sierra Leone, because the Security Council was not going to give it a broader mandate than that. And I think that this still is something that we need to continue to focus on. I talked about flexibility. We won't go too much more into that, but I think it's very important that, if at all possible, and this is the challenge of Louis that the ICC has, and he understands that, and he's trying to think it through, so if you can put it right where the crimes took place, that is really where people can see justice done. And the ICC is in The Hague, and they're going to be prosecuting and investigating cases all over the world, and it's going to be a major challenge for them, of the many challenges that they have, of allowing and ensuring that the victims, which is what this is really all about, ladies and gentlemen, it's about the victims, to make sure that they fully understand. Unfortunately, the victims are in places where they just can't turn on CNN or get some type of feed from somewhere to watch this. Even when we were there, we had a challenge because, of course, there was no communication systems, or there was a very rudimentary communication system. Even then, physically being there, it was a challenge. And so again, it's going to be a challenge, but I still think we should do the best we can, particularly at the regional international tribunals, to put them exactly or close to where the tragedy took place. Outreach is absolutely essential. Absolutely essential, because the things that you want the people to understand is the law is fair, that no one is above the law, and that the rule of law is more powerful than the rule of the gun. And if you think about it, that is the Nuremberg Legacy in 25 or 50 words or less. Really, and that's what I talked to the people of Sierra Leone. I literally walked that countryside for 3 years, standing in front of my client, the people of Sierra Leone, listening to them tell me what took place, listening to them complain to me that they're not happy as to what is going on, et cetera, et cetera. But again, standing in front of them and letting them see their prosecutor, listen to them, was, I think, a great way of showing them that the law is fair, that there's something out there greater than just what they hear. And we built outreach teams, we had district officers, we literally drove tapes of the proceedings to each of the districts where they had machines with generators, and they would show the proceedings of the court that happened a week prior to anyone who wanted to see it. And of course, certainly the tribunal itself was open to everybody within the court. And it was a wonderful thing as I was being driven into the compound of the court to see Sierra Leoneans lined up waiting to go into their court and see justice done. And I think that that's really why we're all here today. Now, the UN is important only in the sense that, yes, we have to have a political decision, we have to have a political support, but in reality, I've kind of alluded to the fact, we have to ask the question, and we can certainly discuss this, is the UN system itself efficient and effective enough to create an efficient and effective tribunal to bring quick and fair justice to some part of the world? And then, of course, I've talked to you about the importance of having a Truth and Reconciliation Commission. I mean, before I came, I read all sorts of documents on how the Truth Commission and the Special Court for Sierra Leone are not going to get along. It's going to be a disaster, and there's going to be great confusion. Was there confusion? Yes. Did we deal with it? We went out in the countryside and explained the difference. Did we quell all the confusion? No, not at all. But at least they began to realize that there's a truth aspect to conflict as well as a justice aspect. And when I was standing in front of these people, many of them would just come up to me and tug at my sleeve and say, look, I want to tell you what happened to me and my family. That's all I want. And the Truth Commission, they can do that. And so I would encourage them individually and collectively to go to the Truth Commission and tell their stories. And they did so by the thousands, telling incredible stories. So I think that we need to make sure that we do have some type of truth mechanism when we go into a part of the world. Because we do have to ask ourselves, is the justice we seek the justice they want? And we have to be very careful about that. And we can talk about the spaceship phenomenon later on in the question and answer period. Let's talk about the challenge of the Jackson and the Nuremberg Legacy. And that's the difference. I mean, ladies and gentlemen, that was my biggest challenge all the way across the board, bar none. People didn't care. I would stand in front of people like yourselves. Yes, you cared, but your care left with the room when you left. But to get governments, to get people fired up about keeping money coming. I mean, incredibly, we were actually doing what the international community asked us to do, and we almost ran out of money about halfway through the whole process in 1973. Well, that's an important part of 2003, excuse me. I'm dating myself here. In 2003, for obvious reasons, the world looked elsewhere. Money was being diverted, interest was being diverted, political will was being diverted. So again, indifference is a huge problem. I don't know if there's a solution. I don't think there is. At the end of the day, and like I tell my students, it really boils down to the success of a tribunal is the political will of the international community, period. It's nothing to do with the tribunals. Those wonderful men and women will do whatever they're asked to do with the resources that are given, not just monetary, but the most important resource, and that is political will. So it's not the tribunals who are failing the Nuremberg Legacy. In reality, it's the international community that is failing the Nuremberg Legacy if there is a failure. So again, huge problem. Political entrenchment, backlash related to the work that's being done. Perfect example in Africa. President Obasanjo would kept saying, because he was a little bit angry that we forced him to take Charles Taylor, and he was saying African solutions to African problems. And what he meant, that's fair. I don't argue with the fact that yes, Africans have to step up and help solve their own problems. But he was also using that as a way, and he said this, I heard him publicly say this in London, is that let Africans take care of their problems, such as crimes that we were talking about here. Let us Africans deal with it customarily. Again, I don't think anybody from just a general point would argue with it. What a wonderful thing to be considered, because we do need to consider custom in our international criminal law approach to trying to face down the beast of impunity. But what he really meant to say is that we want to step outside international norms, and let's have an African exception to the Nuremberg principles. And I called him on that publicly and privately, and he and I went back and forth on the record for quite some time. And then we also have to, and of course we do, and I'm not going to belabor this point, we do have the world's only remaining superpower removing itself from the system, and I think that is really a challenge of the Nuremberg Legacy as well. And then we have, in this paradigm shift on this so-called war on terror, these extraordinary judicial legal arrangements. And of course, it's been manifesting itself incredibly over the past 2 weeks. And I'm not going to belabor the point right now, but certainly that is a huge challenge to the legacy. I'll just give it in a simple point. The loss of the moral high ground of such a world power as the United States is the ultimate challenge, in my mind, humbly, the ultimate challenge to the legacy of Robert Jackson and Nuremberg. Thank you very much. Standing in front of a group of children who were deaf, who had been rendered deaf or had been born deaf in McKinney and around the surrounding child soldiers. And I was listening to them talk through interpreters and other ways. And this young man stood up and he said, and people were kind of surprised. He was 12 years old, and he said, in his atonal way of someone who is deaf, I killed people. I'm sorry. I didn't mean it. And so if we ever question why we need international criminal justice, I would just ask that you remember that young boy who stood up and publicly said at the age of 12, remember the war has been over for 3 years, he said that he had already grown up to be a murderer. Thank you.
I want to say how great it is to be here with my mentors and the people that inspired me to enter this field. Henry King, who I see every day at Case, but also Ben Ferenz, who wrote the introduction to my very first ever published book, and Whitney Harris, who inspires us all. And then also the more modern day versions, Richard Goldstone there, and David Crane, who I'm going to try to follow. So this is just terrific to be here. Topic today that I'm going to be talking about is order in the courtroom, maintaining control when a tyrant is on trial. That's my invitation. I'm looking like a tyrant, I guess. Not a pretty sight. Well, history is full of the challenge of trying to prosecute people who are not so interested in getting an acquittal. Maybe they've made a calculation that they're unlikely to get an acquittal. And they want to turn the trial into something else. Whereas the prosecutor's job is to try to get a conviction, to create a historic record, to deter future crimes, to allow the victims to appear in the courtroom and face their accusers and say "j'accuse" and have a cathartic effect. The defendants and their lawyers have a very different approach to all of this. They're not interested in cooperating. And so if you go back historically to the Nuremberg judgment, you have the first time this occurred where Hermann Goering was toe-to-toe with Robert Jackson. And this was supposed to be, other than the opening of the trial, this was supposed to be the moment that the whole world was going to focus in on. And Robert Jackson worked on his notes. He had his cross-examination questions just so. He was going to do what 30 years later Perry Mason did in all of his TV shows, and he was just going to manipulate Hermann Goering and show the world what a monster this guy is, and even get him to admit his evil deeds and the mistakes of his way and discredit the entire Nazi operation. Well, that was pretty high hopes, and Jackson probably could have pulled it off, if not for one small problem. When he was in the Supreme Court, the person who often was under him and arguing before him was somebody he didn't get along with too well historically, Francis Biddle. And ironically, their roles were shifted now. Jackson was the prosecutor, Biddle was the judge. And when Jackson began his cross-examination of Hermann Goering, Robert Jackson tried to stop him. He said, look, just answer the question, yes or no. And Biddle, from the bench, huddled up with the other judges, and he convinced the other judges to allow Hermann Goering to have free rein in his answers. And that completely undermined what Robert Jackson was trying to do. So for several days, Hermann Goering got to reintroduce the world and the German people to his version of Nazi ideology. And he was a brilliant man. He articulated these things exceptionally well. And fortunately for all of us, that trial was not televised. Because what Christoph was telling me, at that moment of the trial, there was some newspaper coverage. There wasn't a lot of newsreel coverage. Not a lot of people paid that much attention to what Hermann Goering said. Thank goodness. Because this was his opportunity to pull what we now call a Saddam Hussein. It's not the only time that someone has tried to do this at a trial. We heard Larry talk about the Chicago 7 trial. The history there is that in 1968, the leaders of the anti-war movement had organized rioting that disrupted the Chicago Convention. Those people were then prosecuted. Interestingly, the Johnson Attorney General refused to bring an indictment, and as soon as Nixon's Attorney General was put into place, he did bring an indictment, which made it look like a political proceeding. And Abby Hoffman and Bobby Seale and the others were brought to trial in the Chicago trial. You see a picture of them down there. They didn't care much about getting an acquittal. What they wanted to do was make the whole case about the tyranny of the American justice system. And so they were so disruptive that the judge had to, and you'll see a picture later in this presentation, they literally had to put a gag and a bound on Bobby Seale to keep him from totally disrupting the trial. And now it's gone down in history, as Larry May suggested, as one of the most unfair proceedings in history. But you have to ask yourself, if you were a judge, what would you do to handle that kind of situation? And that's really the theme of my presentation. More recently, you've got Slobodan Milosevic there. He pulled a new one. He decided to, because he was a lawyer, to exercise his right of self-representation. And this is why this allows a defendant in a war crimes trial more leeway to disrupt the trial. Normally, if you're dealing with a lawyer in the courtroom and you are a judge, you can say to the lawyer, please behave yourself, or there are certain consequences. You could be fined, you could be put in prison for a night, no lawyers like that. You could have disciplinary proceedings, you could be disbarred, you could be replaced. Now, with a defendant who is representing themselves, they don't have any money, so the fine isn't going to worry them. They're already in jail, but that's not going to bother them. They can't be replaced because arguably they have an international right to represent themselves. And so the judge has very little control of his courtroom once you go down that route. And Judge Richard May found this to be a very difficult proposition as he tried to handle Slobodan Milosevic. Milosevic was very rude to the judge. He refused to call him Judge May, rather he called him Mr. May, and there were several disruptions caused by this, and it made the trial very unmanageable. Now, more recently, this fellow to the right of Milosevic, Sechel, is about to start trial. And in pretrial motions, he has said, I'm a lawyer too, I want to represent myself, and my goal is to be as disruptive and to derail the trial, to be as rude as possible. And the judges got together in a really extraordinary opinion. They said, no, Sejal, you have to have an appointed counsel, because we just can't have these proceedings be hijacked by those kinds of shenanigans that you have already told us you're going to pull. That's a bit controversial. I actually have written an article about how under international law that decision can be justified. But I would suppose that it's more justifiable to allow him every day to represent himself and to see if he becomes disruptive, rather than to take away that right altogether at the beginning of the trial, as they've decided to do. Now, not only are the defendants disruptive, but sometimes their lawyers are very disruptive, causing more of a challenge. What we have here are humanity. There has to be equality of arms. You have to have a super lawyer against the prosecution, so that at the end of the day, the world says, yes, that was a fair trial. And whether the lawyer is able to get an acquittal or not, the lawyer has done his or her job for history, for justice. Now that is a very idealistic and profound reason to represent a dictator, and I applaud that. That's not the reason many of the lawyers do, however. More often you have lawyers like Johnny Cochran up there, and his famous, if the glove doesn't fit, you must acquit pose. And Alan Dershowitz, who has also represented some people that decide to do it because either they think this is the supreme challenge and that excites them because they're at that point in their career that they need that, or more frequently, like Johnny Cochran, you become an obscure attorney immediately transformed into a world-known superstar lawyer. And so a lot of people are attracted by that. None of those reasons are why Ramsey Clark decided to represent both Milosevic from behind the scenes and then Saddam Hussein directly. Ramsey Clark has gone on record as saying, the reason I'm doing this is because I'm against the 2003 invasion of Iraq. I have to say, coincidentally, so was I, but I'm not representing Saddam Hussein today. He did this because he wanted to transform the trial of Saddam Hussein into the trial of George Bush. And while I might find that interesting, I think that that's not necessarily in Saddam Hussein's best interest. It's certainly not in the tribunal's interest, because it means that both the lawyer and the defense counsel have an agenda other than getting an acquittal, which means they're not going to be playing by the rules, which means it's going to be supremely challenging for the judges and the prosecutors to keep control of the courtroom. Well, what kinds of things have we seen in the Saddam trial? And these are things we're likely to see probably in the Charles Taylor trial and in many of these international trials. Saddam Hussein, according to Gerald Post, a CIA profiler, actually focused on the Slobodan Milosevic trial, studied all the things Milosevic did, and then went and used his playbook and then actually perfected it. He was aided, of course, by Ramsey Clark, his lawyer. When we were talking earlier about the 1968 or 69 Chicago 7 trial, I forgot to mention that Ramsey Clark was actually the advisor to the defense team. And so the kinds of antics that we saw then were antics that he either was advising or very familiar with and was able to talk to his client about 40 years later. Well, some of the things that we see Saddam say. In the middle picture, you have him and his brother jumping up and yelling at the judges. He yelled all sorts of things at the judges, frequently. He told the judge, for example, that he was a traitor. He said that he was a whore who had sold out his countrymen and women to the Americans. He called the judge a homosexual. He told the people of his country, go out and kill this judge. He's a bad man. These are the kinds of things that Saddam Hussein was able to say during his trial. How did Saddam get the opportunity to say these things? He wasn't exercising the Milosevic right of self-representation. In fact, the Iraqi legislature had passed a law saying that Saddam had to act through his legal counsel. But interestingly, those of us who had consulted and advised the court and helped train the judges did not anticipate that they were going to apply an obscure rule of Iraqi jurisprudence that says that a defendant is allowed to ask follow-up questions after his lawyer is done of any witness. And that little rule became the rule that swallowed up, or that exception swallowed up the rule. And Saddam has been able to use that to have free reign every single day of his trial, just as if he was representing himself. You see him or his brother, Barzan, appears in his underwear to make certain protests. Down below, Saddam is shaking his fist, probably threatening the judge. He's done everything imaginable to make this a difficult trial and to sidetrack it. Usually he starts these outbursts right when usually a woman or an elderly witness is talking about the terrible things that happened, and he is literally taking the world's media away from that moment of the trial and bringing it on him. One day Saddam, this is not something that was done to Saddam. Saddam brought tape to his own trial and put it on his mouth as a way to say, look, you're not letting me say what I want to say today, and I'm protesting by putting this gag on my own mouth. But of course that's what we see, and we're thinking Bobby Seals, right? And then finally, Saddam and his lawyers have boycotted the trial. And literally what happened at one point in the trial is that the lawyers just got up and decided to leave. And the judge said, where are you going? And they said, well, we're not happy with the way you're doing things today. We're leaving. We're boycotting. And the judge says, if you step out that door, in a capital case, you're going to be relinquishing your right to represent your client, and we will have you replaced with public defenders that have been sitting in the courtroom throughout the trial, that have been trained by international trainers and are ready to step in. Well, the Saddam trial has also been so disruptive that it has had an effect on the judges. The first judge, Judge Rizgar Amin, was selected because he was sort of the world's most mellow judge. And the theory was that Saddam would scream and yell at him and he would just smile. And that Saddam would literally hang himself and no one would take what he said seriously. And literally on March 1st in the trial, Saddam admitted everything. He said, yes, it's true, I ordered the destruction of the town. Yes, it's true, I ordered the 300 people rounded up and sent to Abu Ghraib prison. Yes, it's true, I had them all prosecuted in mass in a one-day trial. And yes, it's true, I ordered their execution. But he said, that's what any dictator, actually didn't use that word, of course, that's what any leader would do when threatened with a terrorist attack and an insurgency. And so this strategy actually was working. Let Saddam do the Saddam thing, and literally he's just going to incriminate himself. The problem was that the Iraqis didn't like that strategy. What they saw every day on television was Saddam getting the better of the judge. And so there was a tremendous amount of public pressure in the media and governmental pressure, and even our own Senator Specter went over and visited this judge and gave him a lecture and said, maybe you should leave. And so Chief Judge Rizgar Amin, who is a wonderful, wonderful person, resigned. And the world said, oh, this is terrible that the judge has resigned. Half the world said this is great, he wasn't doing the trick. It was like a lot of conflicting things. I do have to say one other thing about Iraqis. There's a lot of unique attributes of Iraqis, and we tend to look at these trials through American Western eyes and not their eyes. First thing is, they tend to be very boisterous in the courtroom. They're very aggressive. They yell a lot in their trials. So when Saddam or his lawyers are yelling at the judge, that's not so much out of line for a typical Iraqi trial. And yet, it doesn't translate very well in the United States. And secondly, Iraqis like to protest by walking out. I know this because during training sessions of Iraqis in Dubai, we had the judges all walk out one day when one of the trainers said that you have to be like a pit bull. And the translator said, we have no word for pit bull, what does that mean? And they said, oh, it's the dog that bites the neck and doesn't let go. And all of a sudden, all the judges walked out of the room. And the trainers ran out and said, come back, what did we say? And they said, you can't ever compare someone to a dog in Iraq. It is the worst. They said, think of the worst four-letter insult of your mother, and this is worse. So they do that. And Paul Williams, a colleague of mine, we have an NGO together, he spent the summer while I was working with the judges of the Iraqi High Tribunal, working with the legislatures who were putting together the Constitution of Iraq. And he said that 3 times a day there was a walkout. Everybody was walking out. Well, during the trial of Saddam Hussein, he had a lot of walkouts. Prosecutor walked out one day. Defense counsel, as I mentioned, kept walking out and boycotting. I think ultimately what Rizgar Amin did was a walkout. He was just fed up and he did the Iraqi thing. He left. He was replaced by Judge Raouf. Raouf pretty much handled the case about how you're seeing him there. Strong-armed judge, loves to yell, very typical of Iraqi, whereas Judge Rizgar Amin was very different. And so suddenly the Iraqis were very happy with the conduct of the trial, and I became very unhappy with it because you had a judge who has to find facts yelling daily at the defendant. And this isn't that atypical of these kinds of trials. Judge May, over in the Hague Tribunal, at times had to yell at Slobodan Milosevic, and it caused the same kind of unseemly view, the fact finder yelling at the defendant before the judgment is rendered. The defendants want this to happen. That's exactly what they're trying to accomplish. And it's a real challenge for the judges to try to find a way to maintain control of their courtroom without falling into this pattern. The last judge on the right is Judge Abdullah Al-Amari. He was a bit like the first judge, Amin. He was saying nice things about Saddam. At one point, we know a couple of weeks ago, he said, Saddam, you're not a dictator, at least not until we've had a conviction. And that didn't go over very well. I got a phone call, actually, that night from LA Times and Washington Post, and they said, Professor Scharf, this is what happened. What do you make of that? And I said, oh my God. Well, what they were asking about was the fact that the president of Iraq, after he heard this, reached down and had the judge removed. And he said, I can do this because the statute gives me this power. And I said, oh my God, that's so bad. I mean, this is supposed to be as independent as possible. Under the circumstances, there are all these provisions of the statute that say the judges, the prosecutor can't have any kind of directions or guidance from the regular courts or the government. There's a provision that says that there's no appeal to the regular courts. It's supposed to be a freestanding court. That's very important under international law. And this president has just reached over and violated that. What I found out subsequently, and you all probably don't know this because it hasn't really been discussed in the paper, is that the president didn't unilaterally remove this guy. What happened was the prosecutor had asked to have the judge removed, not just because of that one statement, but because of a number of things he was doing to mismanage the trial. The chief judge and all the judges got together and voted, and they made a formal request in writing to the president of Iraq to have him removed, which is the actual process in the statute for removing a judge for cause. That's a horse of a different color, and I feel terrible that I joined the chorus of people beating up on the Iraqi High Tribunal that day because of incorrect information or not complete information from the press, which is another thing that these trials, all of these trials, suffer from. If an international trial is going to get press attention, the press can't talk to the judges. They're not allowed to talk to the press. Can't talk to the prosecutor. That's unseemly. And who does the press talk to? They talk first to the defense counsel, which set the agenda for the story, and then they talk to outside experts, and we outside experts don't know all the facts. We only know what the press tells us, and then they ask us to comment, which is a very dangerous thing I'm learning. All right. Part of the problem in these modern international trials is that they've decided to televise them. Because once you decide to televise a trial, you're telling Saddam, who's very happy about this in that picture, that he has a stage where he can broadcast to all the people in Iraq and the Middle East and throughout the world. More people are going to see him and listen to him now than ever before. And this is exactly what he wants. The first decision to televise occurred in the very first trial of the Yugoslavia Tribunal. They continued it in all the other trials. In fact, they actually paid through an AID grant to have the televised proceedings beamed to Serbia under the theory that if you televise a trial, it gives you transparency, that people can watch the trial, they will learn from the trial, they will become educated, it will discredit their old leaders, and it will deter them from committing future war crimes. Not sure it works quite that way, but that was the theory. Thank you. So in Iraq, the Saddam show is the #1 rated show on television. Whenever he is testifying, everybody in Iraq goes to the local cafe and watches it. And what they see are often him making these kinds of praise rhetorical speeches. I actually would suggest, if we were starting from scratch, that instead of televising gavel to gavel, that they have maybe weekly broadcasts or monthly broadcasts of the highlights of the trial that a independent organization like the Registry puts together with highlights both of the defense and the prosecution, but rather than having all of this time for the people in the trial to think that they are instantly talking to the Iraqis. And of course, there was another time when Saddam said to the Iraqi people, why don't you go out this afternoon and kill the people that are the personnel of the Iraqi government? And Judge Raouf, who was a little bit different than Judge Rizgar Amin, said, Saddam, shame on you. If they're going to kill people, say kill the Americans, not the Iraqis. Anyway, what can a court do in such a situation? Well, here's our picture of Bobby Seale. That doesn't work well, because that's the lasting legacy. That's our image that we all remember. So you don't want to do that. Zacarias Moussaoui last summer was thrown out of court 4 times in one day for his outbursts. So when the judge in the Saddam trial or any trial throws out the defendant, that shouldn't be a huge surprise. It's not atypical of a situation where a defendant is acting so disruptively. That's what judges do around the world. Adolf Eichmann gives us an interesting idea. This was actually for his protection, not because he was a particularly disruptive person. But if you put the defense or the defendants in a glass booth where you can't hear them unless their microphone is on, then you can literally turn off their microphone and get some semblance of control that way. They've tried this at the Yugoslavia Tribunal and the Rwanda Tribunal and other tribunals. They've tried it in the Saddam trial, but the courtroom is not set up for it to be effective. You can still hear them through the glass wall, and you can certainly see them. I suppose someone like Saddam would find a way to circumvent this, including by maybe banging his head against the glass, just to be disruptive, and what can you do? So all of these ideas have their own difficulties. We have been debating on the Case Western Reserve Saddam Hussein trial blog, how do you handle these kinds of issues, plus another 50 issues related to the trial. Many of the people in this room today are among our expert bloggers. And what I'd also like to suggest is that when the verdict comes out in 2 weeks on October 16th, if anybody here, because you are all experts in this area, if you want to put an essay about your thoughts on the verdict, the judgment in the Saddam trial, we will post it not as just an essay from an ordinary person, but as an essay from one of the experts. That's David Sheffer's essay there, and I see David back there. Well, some of the things that we've discussed about how do you control a defendant in this area are pretty novel. One thing that seems to work is if you appoint the standby counsel early on, and if you announce the rules to everybody before trial of the conduct, then the world will know that there are these standby counsel that can come in, that are well trained, that have been there throughout the trial, and are ready to act if, for some reason, you have to get rid of the regular counsel, or if the defendant is acting disruptive as well. Other things you can do when you throw the defendant out, for example, you can have the defendant watch the trial from his jail cell, and maybe borrowing a page from the Gore-Bush debates. Remember when Everett Bush was speaking, there was a split screen and we could see what Gore was thinking and feeling, the expressions on his face. He didn't know this, unfortunately for him, because a lot of people think that that's what lost the campaign for him, or the election for him. He was acting very petulant, and you could see that he didn't agree with anything that Bush was saying. He was making faces and so forth. Well, you could create a virtual presence of Saddam Hussein in the courtroom, or these people, if you show them watching the trial, and you got to see their expression, and you put them in like a little box or a split screen, so that the world could see that they were, if not in the courtroom, at least participating in their trial and involved in the trial. Because the alternative of just having them sit in their courtroom and not be in the courtroom means that the victims don't get to have that moment of j'accuse. It means that the press and the media attention just disappears. They don't want to come if Saddam's not there. And sometimes I think that maybe the price of getting the world's attention is to have a little bit of antics involved just to spice things up along with the trial going forward. And these trials actually, in the Saddam case, did move forward. In the first trial, a tremendous amount of evidence came in. It's really going to end up being like Nuremberg, a documentary case, a case that's based almost entirely on documents that have been authenticated. So you see out there on the stands that there's a book that we've just written. It's full of these essays that were on our website and additional essays that have been written. It talks about all of the interesting issues involved in the Saddam trial. And if you are a law professor and you think you might want to use this in the classroom, I'm not supposed to tell everybody this, but you guys are mostly academics, or a lot of you are. You can get free copies if you just email Carolina Academic Press and say that you want a review copy for possible adoption. But the idea is that we're trying really to have people wrestle with the lessons of the Saddam trial. A lot of people think the Saddam trial has been a disaster. It's definitely been one of the messier trials in history. But Saddam is like Goering. He's like Milosevic. He is a huge figure, and this is going to be a historic trial. And for that reason, good or bad, it's going to be an important trial, and we can learn from it. We can learn historic lessons. And one of the lessons that we can learn is, and at least we can anticipate, what's going to happen in the future. When Charles Taylor is tried before the Sierra Leone Tribunal sitting in the ICC, and he starts trying this stuff, what are they going to do? Interestingly, Luis Ocampo invited me up last Monday to speak to his staff, and I did this exact same presentation, and we had a 2-hour discussion about all these different ideas that they could try in order to maintain control in the courtroom. No one's had a discussion like this before a trial before. So maybe the legacy of the Saddam trial is that we'll finally learn how to deal with this challenge. Thank you.
The tribunal obviously can control and rule irrelevant to defense strategies, but like the retained counsel in the Sept case, like any attorney retained or volunteered, good aggressive defense is a part of an adversary system, which these tribunals are. So I'm wondering if there's a principle of excess that you've observed in these different proceedings, and also what your thoughts are about the participation, or generally the non-participation, by American lawyers in the defense function in these various tribunals.
All right. First of all, about Ramsey Clark, 2 quick stories. One is, at the beginning of the Milosevic trial, even though Milosevic had declared he was going to represent himself, Ramsey Clark was one of his lawyers in the background. And he actually drafted a brief, which has now been called the brief to discredit the court. He never filed this brief in court. It was really bombastic. It said things that were legally incorrect. It was very upsetting to the judges and to the people involved in the tribunal. Instead of filing it in court, he filed it with the press. And for a while, a lot of press stories were involved in that. That seems like something that a defense counsel ought not be doing, first of all. And that was all part of Ramsey Clark's strategy. Secondly, in the Saddam trial, what Ramsey Clark has done is he's been the chief architect of the idea of boycotting, of jumping up and leaving the courtroom. If anybody tried that in a U.S. court, you'd be disbarred. You're talking about a capital case, and you don't like some procedural decision of the judge on a particular day, and you just stand up and leave. And this is really Ramsey Clark's part of his architecture. And that's not, I think, helping so much. Now, on the other hand, these public defenders, I've been extremely interested in their performance, because the press at some point was very critical that they were ill-prepared, they didn't know what they were doing, they weren't asking enough questions. And then at some point, the press didn't realize that it was the court-appointed public defenders that were actually trying the case, and literally, those are the people who gave the closing arguments. The press accounts of the closing arguments of Saddam's wonderfully qualified attorneys was very glowing, but they forgot to mention that these weren't Saddam's hand-picked attorneys, these were the public defenders. So I think that this idea of public defenders is a really important one, but the problem in the Saddam trial was that they didn't explain it beforehand to the world, or probably lay the ground rules clear enough to the defense as well. And so, when you talk about the role of the defense counsel, that's a role that I think is really important to focus on.
That's a very good question, Richard. Again, it boils down to my main thesis is that the law is fair, and it has to be seen as a fair process. And each of these tribunals have addressed those challenges of proper defense counsel annexed by accused in various ways. What we did in Sierra Leone, immediately we realized we were going to have trouble with Inga Norman, who was the sitting Minister of Interior, who we arrested at his desk for war crimes, crimes against humanity. I gave the opening statement, and that concludes my opening statement, Your Honor. And just as he was about to say, well, we're going to take an adjournment and start the case after lunch, Inga Norman immediately stood up and shouted, "This is an unfair court," and fired his defense counsel right in front of everybody. Well, of course, you know what he was doing. He was doing it. It was choreographed, I'm sure. It was planned, and he did it to deflect what I would say was a pretty devastating opening statement. And he realized that really he is not, if this goes fairly, he's not going to leave this tribunal other than as a convicted, fairly convicted indictee. And that continued. Most people don't realize is that most of the indictees in the special court haven't been in court for over a year and a half. They've all boycotted it. Some of them come and go. We have standby defense counsel. Most of the lead counsel have come back when they realize that this is going to go on with or without them, because again, this Office of Principal Defender really kicked in when we had these disruptive incidents, and they were being properly represented. And so the lead counsel realized that, wait a minute, they're going beyond me. I mean, I'm going to no longer become relevant here very shortly. So they came back and continued with the case, but without their client, who could watch the proceedings in their detention center, which they do. And each day they have to waive their right to be present. And some of them come, some of them do not. But 90% of the time, most of them are not in trial. Now again, your question about Americans not being involved in this, it is an interesting question. I've really never thought of it. We had one American from Alabama come and was representing one of the indictees. Lasted about 3 months and then asked to be removed. And because his indictee didn't like him. It was a cultural issue. And so what's ended up happening is that he just couldn't identify with him. There was too much of a cultural gap. And what we've seen now is we have in the various defense teams, we have a lead counsel, either from Sierra Leone, West Africa, or from Great Britain, because that's their tradition. And then we also have a backup counsel who is the flip side. It's worked out fairly nicely.
The gentleman in the picture can.
I wanted to ask two questions. One, David, and probably Michael too, is that in terms of how to integrate transitional justice with prosecutions, international prosecutions, or special prosecutions, what is the role of the court? Now I'm also trying to think of the role of the International Criminal Court in so-called positive complementarity. What is a legitimate role for the court in trying to help instigate both complementary prosecutions, much less transitional justice mechanisms? What is the role of the national legal systems, the neighboring legal systems, the sub-regional, regional legal systems, and others? And how long is it going to take us to sort out? Or will it all be ad hoc, each conflict that we're going to try and figure out how to proceed with this?
Again, an excellent question, and certainly one that we need to continue to move forward and question and ask ourselves all the time. Now, transitional justice is just that. And what is the role of an international prosecutor? Is it just going in and trying them all and let God sort them out, so to speak, or is it something more? I personally believe it's something more than that. And a prosecutor is not just someone who is seeking justice in some part of the world, but he's also a diplomat, he's also a politician, and he certainly has to understand and be able to work with the social and cultural issues that float all around him throughout the process, and become very comfortable with the local NGOs, civil society, regionally as well as locally, and be able to have a good dialogue with them. I had a board of advisors that was made up of civil society, to include the Amputee Association, that met with me once a month, and their job was to be a sounding board and to tell me what's going on, what their perspectives are, where we're missing the boat, not from a justice point of view. I mean, these guys, we had a good case against them, but just from a social and a transitional perspective, are we doing the justice we want or the justice Sierra Leoneans want? And I thought that was very helpful. So in my opinion, the role of the court is more than just to seek justice. Some of you may disagree with that. To the extent that you can, resources allow you. We had a legacy program. You obviously know about the outreach program. But we also had a legacy program which we had developed, and we were actually doing things, training Sierra Leonean police in witness management and protection, quantifying and working with paramount chiefs related to local justice. I mean, really, most of the justice that is delivered in that part of the world, particularly Sierra Leone and Liberia, is done by paramount chiefs. And it's been working for about 10,000 years and actually pretty efficiently. And the question was, how do we, in fact, train them in some things and to quantify some of their rules of procedure, etc. So we did have a legacy issue related to that. The national legal systems don't exist. I mean, it's not that they should have a role. In fact, they should have a very important role. But when I got to Sierra Leone, there wasn't one. I mean, 90% of the courts were destroyed. A lot of the lawyers were gone. Many of the judges were killed or had gone on and moved somewhere else. So, they're just not going to be able to. And then you overlay that with the fact of the number of defendants. What court system in the world can handle 30,000 defendants fairly? It can't be done. It just can't be done. So again, as I threw out there, greatest responsibility at the international level. Hopefully there's a transitional aspect of it of trying to build up and jumpstart or restart a nascent judicial system to move forward and not look back.
Let me add to that. Philippe Hirsch is going to be speaking tonight. When he spoke at Case recently, he was asked a similar question. And he said that for the International Criminal Court, its main short-term success is if it can induce the creation of hybrid tribunals or domestic prosecutions assisted by the international community. And he pointed out that that's really what the Saddam Hussein trial should be. And I think it'd be better, of course, if it was more international and less U.S. in terms of the optics, but that's the idea. Now, interestingly, the Saddam trial, in the long run, if it's seen as a terrible disaster, may actually push more cases to the ICC, because the idea that the ICC comes in when a country is unable or unwilling, the unable bar will probably be, I guess, lowered, because they'll say, well, Iraq said it was able, and look, it wasn't necessarily able, even with the United States assistance. So that's another reason why people, I think, are focusing very carefully on the Saddam trial, because it has an effect indirectly on the way the ICC will play out in the future.
I'm going to take two more questions. Leland, why don't you go ahead and then this gentleman here, and then we'll let the panelists respond.
Well, I want to thank both of you for absolutely splendid, wonderful presentations. And I just have a couple of thoughts tying into what we talked about yesterday, and I'd love to get your reactions. One is on the Saddam Hussein trial and this whole issue of disruptive defendants. David, you were working in a basically common law system. The American adversarial system is something we heard yesterday from Scharf, was very much a legacy of Nuremberg, and we think may have been a problem in the ICTY, that maybe there was too much common law approach to things, and Scharf suggested maybe if we have a juge d'instruction, a more civil law approach, we could avoid some of these issues. And the ICC did move in the negotiations a little less away from the common law, very adversarial situation to a more civil law. So I'd love to get your reactions to that idea. The other is, I think what is wonderful is in Sierra Leone, and maybe David, you can speak a little more to this, they did make the defense an organ of the court. And this is something that in the ICC, there were a lot of NGOs saying, let's do that, and ultimately it wasn't done. And how does, getting that professional sort of defense quality there, would that help both the disruptive defendant problem, and is this something that maybe in 2009, when we look at the ICC statute again, this is something we should revisit?
Go ahead.
This is you want me to notice that the Liberia and Sierra Leone asked that he be removed. Would it be nice to have him tried in front of the people of Sierra Leone? Yes. But again, you have to understand the extreme security situation. We're talking about the most powerful warlord in Africa. The man has reached far beyond just Liberia. And he is a thug. He is someone who has close ties with terrorists, gun runners, diamond dealers, Ukrainian mafia, and he just needs to make one phone call and something could happen, and mostly it would be negative. So yes, absolutely should be in Freetown. I support that. However, it's very important, and please understand this, and this has gotten convoluted in the press. The ICC isn't trying Charles Taylor. The ICC has been very kind to allow us to borrow a courtroom. Under Article 4 of our statute, we can remove the court anywhere we need to. It was potentially put there in case we had to high-daddle Freetown and prosecute where it was appropriate. So that's my point.
And just to quickly address Layla's civil law question, the first observation is that the civil law approach is quite different in different parts of the world. So for example, in Iraq, under their civil law approach, they allow the defendant to ask these questions, which had caused the door to open for obstructions. In some civil law countries, a defendant would have to ask the judge the questions, and that would be much more civil for a civil law system. I'm off to Cambodia in a couple of weeks. I think that their system is more civil law oriented. I'm going to be doing a crash course now to try to figure out what I can tell them that they can take away from these other experiences. And again, it's that cookie cutter issue. These systems are quite different. It's not just common law or civil law. Each country has its own version, and that creates unique challenges as well.